On the record in cause number 324442. The case is style of State of Texas versus Glenn William Fink. Mr. Fink, would you please raise your right hand? Mr. Fink, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, Your Honor.
Okay, Mr. Fink, you may put your hand down. How you doing, Mr. Fink?
Okay.
That's good, Mr. Fink. Your case is on the court's announcement docket this morning, and you're here represented by your attorney, Mr. Jack Lawrence. Mr. Lawrence, do you have an announcement for the court?
Your Honor, I do have something that's kind of problematic about this case. Give you a little very brief history. Mr. Fink was arrested for this case and for a felony case at the same time on July 12th, 2018. And I've got the Sheriff's Department documents right here. July 12th, 2018. He subsequently spent 8 months in jail before he was able to bond out. Now, and we just checked in your office, and they had a warrant for him, which he went back in on December 23rd and got back out on December 24th of last year. But that he had already served 8 months. Now, here is the offer. I'll just give you the letter.
Now, Mr. Lawrence, I mean, whatever offer the state has made to you, the court does not need to be aware of that. That's communications between you and the district attorney's office. That's part of your negotiation. The court does not get involved in any of the negotiation. The case is set on the court's announcement docket, and so only the court just wants to know whether or not your case is, you're going to set it for trial, whether or not you need additional time for discovery, or you need additional time for negotiation.
This is what I was trying to get to, Your Honor, is that they had offered as one possible plea.
Okay, Mr.
40 days in.
Okay, Mr. Lawrence.
What I'm saying is he's already served.
Okay, well, that's between you and the district attorneys regarding the negotiation. Now, if only thing the court wants to know on announcement is whether or not y'all have a plea bargain agreement. If you do, you can inform the court that you do. If you do not have a plea bargain agreement, then the next step is whether or not you want to set your case for trial, or whether or not you want to go before the court on an unagreed plea, or whether or not you need additional time to further negotiate with the district attorney's office or, concerning the case. So the court will not get involved in negotiations of this case, and the court is not going to get involved in any pre-negotiations that you and the district attorney has actually been involved in. Okay, so only thing at this time the court wants to know how do you want to proceed? Do you want a trial? Do you need additional time to further negotiate, or do you want to enter a plea? Or the plea could either be agreed or unagreed.
Well, what we would do, Your Honor, is we would continue to negotiate with the DA.
Okay, so what we'll do is we'll reset this case. We'll keep it on the announcement docket to give you the opportunity and the time to continue your negotiations in this particular case. Okay?
Yes, Your Honor.
Okay, so at this time, what the court is going to do, the court is going to reset the case. You can get with the court coordinator and let the court coordinator know how much time you think you may need to further negotiate with the district attorney.
Yes, Your Honor, because Pam French has moved up.
Okay, okay.
One thing I'm curious about is, does the court take into consideration when it looks at a situation where sentencing may now be a moot issue, does the court recognize that pretrial detainees get 2 days for one served or just 1 for 1?
Well,
Your Honor, this is something that he could take up with the sheriff's department as far as how much credit this guy has, and also it's it's something he can address our office with at any time. And this isn't a discussion that we need to have in the court. It's not very economically judicially.
okay.
Well, Your
So,
Honor,
hold on, Mr. Lawrence. Your case, the court is going to reiterate that this case is going to be reset to give you the time that you need to continue your negotiations with the state. And if you need to research any matters concerning the question that you just asked the court, that will also be a part of the time that you will have, that the time that your case will be reset to. So get with the court coordinator so she can give you the necessary time that you need to answer or to address those questions. The court is not in a position to answer what legal matters that you as a lawyer can research upon your own.
well, I was wondering if the court would take judicial notice
The court is going to
if the court would take judicial notice of something that's an existing law ahead of us appearing for a trial or something like that, it help us make our decision about whether or not to go to trial.
well,
If the court would take judicial notice of an existing law.
the court is going to follow the law, and that basically, as I said, this case will be reset to give you the time you need to do your necessary research. If you have any questions regarding that research, when we come to court, come to trial, you can present it to the court in the form of either a brief or, and then the court can do its research if it needs to do that.
Mhm.
Okay? So
All
at
right,
this
thank
time,
you.
this case is going to be reset, and you can get with our court coordinator so that your case can get reset.
Yes, Your Honor.
Okay?
Thank you.
Okay, you're welcome.